Good afternoon, everyone. I am Darren Sall. I'm your employment lawyer today. Samfiru Tumarkin's employment law Q&A on Facebook and YouTube. Thank you. I'm joining you from Vancouver today, British Columbia. Slightly overcast today, so I'm hoping everyone's having a nice day. We're streaming live to everyone in BC, Alberta, and Ontario. Thank you for joining me today. This is your chance to have any employment law questions you have had in the past, or currently have, or have ever wondered about answered. I'm here for the next 30 minutes to answer all of your questions. There's no question too small. There's the odd question too big, but we do what we can on the show. If you do have a question that requires a little more in-depth explanation, or that you're maybe not comfortable, disclosing on the air, personal issues or what not that need to be disclosed or talked to, free to contact us directly. You can contact me, anyone at the firm, depending on what jurisdiction you're in. You can go to employmentlawyer.ca. I think the card's up at the bottom there. You can go on there. You can contact any one of the lawyers. Our wonderful intake team. We've got a large intake team across all provinces here that we operate in to help you get the help that you need and to hook you up with an employment lawyer, so we can address your situation and let you know your rights. While we wait for a couple questions to come in here, I'll just let everyone know, I am in BC. I practice in BC and Alberta. If you have questions from Ontario, our next session is with Lior Samfiru, the employment lawyer himself, Wednesday, August 10th at 1 p.m. Eastern time. And so you can log into that. We have shows that stream weekly. You can hop in. If I don't get to your question today, I try to get to everyone's questions. If I don't get to your question today, feel free to log into someone else's stream. You can ask your question there. I'll see you again in 2 weeks as well. And if you really want to have your answer from me, then I'm happy to do that. If you find these valuable, we all love doing these as a free resource to the public. If you find these valuable, hit the like button, hit the subscribe button. You'll know when all of the shows come up. There's notifications for that, and so you never miss anything. You can head to our website, and that will give you access to all of our blogs, all of our past recorded shows, and the card's up again. It's employmentlawyer.ca, www.employmentlawyer.ca. And we have resources on there: blogs, news shows, radio shows, interviews, pre-recorded sessions like this on our YouTube channel as well, and our Facebook channel. You can go and see if your questions have been answered, or just peruse and see what other people have been asking. So while we wait for some questions to come in, there's been a couple things going on in the news that I wanted to address. And one of them is the recent announcement from Suncor that they'll be selling Petro-Canada fuel chains, or that they may be selling their 1,500 locations, and what that could mean for employees, really across Canada. And in a situation, it's not exclusive to this, but it is a good jump off. But in a situation where your employer is looking at selling the business, the existing employees obviously are always worried: am I going to be kept on? And if I'm not kept on, who owes me severance? So we've got a couple of questions coming in here. So I'll finish this thought real quick, and I'll try to come back to this if we get another break here. But typically, where a sale of a business is done, you are owed severance if your employment is terminated from the seller of the business. The purchaser of the business will typically either keep the employees in place, and if that happens following the sale, then your right to severance would move over to that new purchaser, as your employment would either continue with that person, or you may be asked to sign a new employment agreement. And in those cases, depending on the terms of the agreement, so let's say you're working for business A, it's sold. The new owner gives you an employment contract and says, hey, if you want to continue working, here's the agreement that we want you to sign. There are a number of considerations you want to look into to make sure your length of service is accounted for, because that will really impact your severance. To make sure that your benefits, you don't have another waiting period, or you're not being transitioned where you're going to have lapses in benefits, to make sure key terms aren't changed. And depending on what that new agreement looks like, you may just be entitled to your minimum entitlements if it's unreasonable for you to not agree to that new contract. Or if it is unreasonable for you to agree, too much is being changed, too much is being pulled away from you, or too many new responsibilities are being foisted on you that were previously outside your job description, you may be owed severance from the seller of the company, as they're effectively terminating your employment through the sale. So in any situation like that, they're very nuanced. It depends on a number of factors. And could depend on your specific situation. Contact an employment lawyer, reach out to us, and just to get a more full view of your rights. And so that's our first question here. We have Arlene from Facebook. Arlene asks, I was recently let go from my position. They're offering me 4 weeks of pay with an additional 2 weeks if I sign before the deadline. I worked there for 7 years and didn't see this coming. If I don't sign before the deadline, do I lose all of my severance pay or just the extra 2 weeks? So it's a great question, Arlene. You worked there for 7 years. You should be getting more than your 4 weeks plus the 2 additional. Depending on your position and whatnot, the Employment Standards Act mandates typically a week for every year you've worked there, up to a maximum of 8 weeks. So I think your existing offer falls short. In this situation, you could be owed, depending on, again, your position, the presence of an employment contract, what that contract says, whether there's terms in there that do limit you. You could be owed, much, much more than 6 weeks of severance. Arlene, I would encourage you to reach out with your specific contract if you have one, or to speak with us, because I think that you are likely entitled to much more than you're being offered. Generally, though, when it comes to your question here, if you're being offered your minimum entitlements under the Employment Standards Act, and they're offering you an additional sum if you sign by a certain date, your Employment Standards Act minimum entitlements are exactly that, minimum entitlements. They set the floor. So you are owed that on a termination without cause, no matter what. In situations like what Arlene's dealing with here, where they're offering an additional 2 weeks if you sign, and I'm assuming it's a release, which means you won't sue them after you sign for that. If you sign that release, you get the additional 2 weeks. If you don't, you should still get your minimum entitlements. So for Arlene's case here, you're risking the 2 weeks if you don't sign. But given your length of service, I don't know what kind of job you're coming from in your particular situation, Arlene, I would suggest you reach out. I'm happy to speak to you. Call our intake line. Any one of the lawyers in BC, I'm assuming you're in BC, Alberta, or Ontario, would be happy to speak with you, just to get a more fulsome view of your situation and to give you some, more tailored advice on how to move forward with this. But I think you definitely, there's enough question marks raised here by your question that, I think you should have this dealt with and dug into a little more. But generally, yes, if you don't sign, judging by the way you phrased your question here, Arlene, it seems to me like you're just risking the 2 weeks of severance. But like I said, it seems to me that you may be entitled to much more. All right, and I think we have, okay, this is a double question here. And so we have another email question here. This is from Pat. Pat asks, is there a difference between a layoff and being fired? Why do major corporations announce that they have laid people off if they aren't going to be brought back? So, Pat, that's a great question. I can't speak to why major corporations announce it in this way. Layoffs generally sound better than we're firing a large portion of our workforce. It just sounds friendlier, I think. There are provisions within the Employment Standards Act that deal with layoffs specifically. For example, you can lay off workers for a certain period of time within, 13 out of 20 weeks. And if you do that, you're not, you can recall them to work, and it's not a termination of their employment. If you break that period, so let's say you lay them off for 20 weeks, 20 consecutive weeks, then that person's employment is deemed terminated by operation of law, and they're owed severance at that point. Layoffs are a way to, generally give employers a reprieve from payment to their workers without triggering severance obligations. Okay, a lot of contracts will have it written in there that employees agree to be laid off in accordance with the needs of the company. And if that's the case, then you may be stuck agreeing with layoffs. But like I said, the Employment Standards Act does permit employers to lay off workers for a period of time within a larger period of time without automatically triggering a terminating event. So that, I mean, that's a great question. Like I said, as far as the reasons that they do it this way, it gives them a bit of a reprieve. Generally, from a PR perspective, I think it does sound a lot better. Layoff is kind of a more passive term as opposed to firing, which just has a much more negative connotation to it. So it's probably a mix of both. And so we have another question coming in through. So Pat, I hope that answers your question. If you have any more, feel free to pop into the chat here. We have another question here from Belinda Beguiling through YouTube. And Belinda asks, I've been working day shifts for the last few years, but my employer has said they want to switch me to nights. I have children and cannot work these hours. What can I do? So, Belinda, that's a great question. I mean, that's a real difficult situation they seem to be putting you in. It'll depend on a few things. So one, it depends on the terms of your employment contract. Whether you're obligated to only work day shifts or whether you're obligated to work both days and nights. I'm guessing from the fact that you've been on day shifts, that's been your primary source of income and your relationship with the employer. If they want to switch you to nights, but you have children and can't do this, they have an obligation to accommodate you. Right? So this could be a human rights violation based on family status. In this case, childcare prevents you from being able to work nights. And if they discriminate from you or against you on this basis, you may have a viable human rights claim. We need a little more detail as to, for example, what your work is, why you've been on days, again, what your contract says and what discussions have been had in the past, how long you've been on day shifts, and if you've taken any nights. There's a couple things that I'd want to go through, or that should be gone through with you by an employment lawyer before dealing with this. But generally, your employer does have a duty to accommodate you if you have childcare issues like this. You can't just unilaterally switch your job. I mean, switching from days to nights is quite intense, and it's a very big lifestyle change. Especially for someone with kids. Even with someone without kids, it's a very big change to your employment. And that could result in a constructive dismissal. In this case, it could result in a constructive dismissal plus a human rights complaint. So I would say, Belinda, just so we can give you a little more tailored advice, feel free to call in or to email in. You can email help@employmentlawyer.ca, email your question in and ask to speak to a lawyer. Our helpful intake staff will set you up with someone, either myself, you can request me, or you can request any one of our staff, or just anyone in general. And someone will reach out to you and give you some more tailored advice where we can actually talk through your situation, get a little more background, and make sure you're set up moving forward. Something like this doesn't necessarily always end up in a termination. Sometimes you need to just be able to talk to your employer, knowing your rights. And a lot of the times, some employers just don't know that they can't do this. And when you inform them of that, or when they get a letter from a lawyer, they say, okay, didn't know I couldn't do that. Makes sense. We'll keep you where you are. So, sometimes there's, the path of least resistance is still one we can take here. So Belinda, hopefully that answers your question. Let me know if you have any additional ones. Moving on here, we have a question from Jude on Facebook. Jude asks, I'm wondering how outside workers aren't allowed to stay home. It's been so hot, and 8 hours of this is not work. It's like punishment for anyone working outside. So I'm assuming you mean in the heat recent heat that we've had. Well, generally, if there's no state of emergency or reason why people can't work outside, where it's too dangerous to be outside as opposed to just uncomfortable, then there wouldn't be a right to do that. If you have an outside job, that might be something you take up with your employer. If it poses a safety issue, dehydration or things like that, then you may want to raise that with your employer. You have avenues through WorkSafe if it poses a safety issue for anyone on the job. If you have a particular medical issue, you want to raise that with your employer as well. There are duties to, like I was saying with Belinda there are duties to accommodate for things like medical conditions, physical disabilities, and just general safety issues. For example, if it's 45 outside and the government's advising everyone to stay inside and your employer's saying no, go work in the beaming sun, you may want to talk to WorkSafe about that. So that may pose an occupational health and safety risk. If your employer is giving you breaks and water and things like that, or providing things to help you through that, like an employer may want to do, then you may not have much of a recourse. But I would say address it with your employer. Address that with WorkSafe. Generally, inclement weather won't have a massive effect on your requirement to work. It may just make certain work unavailable. And so Jude, hopefully that answers your question. I mean, I get where you're coming from that. It's been very hot, and I think things like accommodating workers with micro breaks, more water breaks, the ability to work in shade, or depending on what kind of work you have. For example, if it's landscaping, maybe your hours shift and you work more into the evening where it's a little cooler. These are all things I think you address first with your employer, and then second, you can look to different avenues such as WorkSafe or an employment lawyer to speak with you and to try to help you navigate that. And so we have a question from Bill on Facebook here. Bill says, am I able to sue for the pension loss I will incur for the period of severance I may be entitled to? Generally, yes, Bill. It depends on what kind of pension plan you're under and what the contributions look like. But if it's a standard, pension contribution scheme and there's no limiting factors to that, that is something that we typically include in a severance negotiation, definitely, over the notice period, because it is a loss that you'll be experiencing. And, under the Employment Standards Act and under the law, you're entitled to, all of your compensation, your guaranteed compensation for the duration of the notice period. The notice period acts as though you remained employed. So pension losses would be, pension losses would be covered in there. For example, some companies have RRSP contributions. So automatically every check, 5% gross RRSP contributions are made. We include that. That's something we always try to include. So if you have a specific question beyond that, Bill, let me know. Hopefully that answers your question. But generally the answer is yes. Any part of your compensation that you are paid in the normal course of your employment is something we do pursue during the severance period. There are exceptions to that, but they're slim and rare, and it's always a case-by-case analysis. But if you have a consistent source of income that's coming in from the company, however it looks, then yes, that is included. And so Belinda has followed up with, thank you. I've been working at a gas station, but only on days. I do take some weekend shifts, but never overnights. So yeah, Belinda, like I said, I think that this would trigger the duty to accommodate here. Weekends are much different than during the week, and also much different than nights. If you have childcare issues, I would raise this. If they terminate you because of this, and they say, listen, you have to be able to take night shifts, we're not going to be able to accommodate you. It's a weird situation. It really depends on why they want to switch you. If there's just no day shifts available anymore, which I don't understand how that would be the case, given that it's a gas station, then there may not be discrimination there. But given that they just want to move you, I would say that's maybe sufficient to backstop a claim for constructive dismissal if they force the move. And potentially for discrimination as well. I would say call in, I'd want to talk to you, or someone should talk to you a little more in depth about your situation, get a little more history, and of course, review any employment contract that you might have, because that can serve to limit and curtail your entitlements on termination. And that may weigh into your decisions. I mean, for you, it seems like you don't really have a choice in this in any event because you have children and you can't work overnights, but it's good to get a good view moving forward. So we have a question from Ryan who asks, are you guys going to add the 400 price just to hear if you have a case in your ads? So Ryan, a lot of our consultations are free. We do charge for things like contract reviews, and there are certain consultations that just require more work. They do require us to review, a number of documents, depending on the case. Each intake is always assessed and determined as to whether it will be, either free or a paid consultation. And so depending on the situation, whether there is a termination in effect or if it's just general advice, that will obviously, dictate the type of consultation that you're offered. And we have 2 questions here from Jay the Travel Dude. I like the name. I'm right there with you. And through YouTube, he says, I sued my employer back in April. I'm on medical leave and have not exhausted my short-term benefits. On June 26th, the company discontinued my pay as well as medical insurance. Any remedies you have? I'm suing for racial discrimination. So I'm assuming you're on short-term disability, Jay, and that you haven't transitioned, obviously, into long-term yet, although you seem like you might be there. Discontinuing your pay, I'm assuming you're getting paid through disability benefits. I'm not entirely clear on that, but for now, I'm just going to assume you're getting paid short-term disability benefits through some type of long-term insurance provider. And your medical insurance, I'm assuming that is your extended health care, your extended medical coverage through your employer. Unless you have, as a term of your contract, that the company is required to provide you with extended health care, like your benefits are outlined in your contract and they're not just like a value-added provision to you. Okay, so thank you, Jay. So Jay just says, yes, I'm correct. It's on short-term disability. He's on short-term disability, or he's on short-term disability. So Jay, unless you have an employment contract that sets out that you are entitled to benefits, including extended health coverage and whatnot in your contract, your company does not have to keep that up. They don't have to keep paying the premiums for you. What they will usually do is they will ask you to continue paying your premiums yourself so you can keep that coverage in place. So if they're discontinuing those, like discontinuing your pay, they won't continue to pay you while you're on short-term disability. Short-term disability is income replacement insurance, so you can't get pay from your company plus short-term disability. So you are limited to the short term for that. I would approach your company if I were you and just say, listen, you guys are discontinuing, unless you have a contract which says, Jay is entitled to X number of dollars in compensation and extended health benefits that the company will pay for, or extended health benefits and outlines all that for you. If you have a contractual entitlement to that, then they have to keep that in place. If they pull that away, then you may have a claim for constructive dismissal of your employment. The catch-22 with that is that any severance you get would be deducted from the short-term disability payments, because both are technically income replacement. So, you've got a very particular situation here, Jay. There's some maneuvering that may be required, and the advice that you need is very specific. I'm just speaking generally about this topic right now. So I think, you should call in if you've already sued your employer. I'm going to assume you have a lawyer already, unless you just sued in the Human Rights Tribunal by yourself. So if you have a lawyer, I would encourage you to talk with them about this. If they're not an employment lawyer, then I would encourage you to give us a call, or give an employment lawyer a call, just to discuss the specifics of this. Because with the long-term disability claim in the background, and the long-term disability claim in the foreground, and your employment issues in the background, you want to make sure you don't disturb either. And so at our firm, we handle both. As you can see, this is a cross section that does happen very often. There's an intersection between disability and employment very frequently. I practice in both areas. A number of our other lawyers do as well. So reach out to us if you're in BC, Alberta, or Ontario, Jay, and you'll be hooked up with the correct individual to speak with, so we can help you navigate both ends of your claims if you don't already have a lawyer. All right. And Carrie Smith comes in from YouTube. Excuse me. Carrie asks, can an employer put a limit to your health benefits coverage if you don't go on leave? So I'm not quite sure what you mean about leave. So generally, health benefits coverage is set by the insurer. So most employers will have a group policy provided through any number of insurers, Sun Life, Manulife, Desjardins, or whoever else. There's a number of them, and usually those group policies will set the terms of the coverage. So you'll get a policy booklet which will tell you, for example, you got $500 in massage coverage. You've got $500 in physio coverage, and that's what the limits are set by. Your question leads me to believe, Carrie, that your employer may self-fund benefits, so they put their own benefits in place. And your question kind of ties in with Jay's question, which is if you have a contractual entitlement to a group benefit, and that's enumerated in your contract, and it says you're entitled to whatever's under the group policy, and the group policy is what it is, you're entitled to that. Okay, if it doesn't outline what your entitlements are, if you don't have a contract that entitles you to, X number of dollars in massage, X number of dollars in chiro or physio or prescriptions, and if your employer self-funds it, then you don't have a blanket right to it, and they can modify that as they see fit. A lot of this really depends on your contract and the presence of that, or any discussions. If there's no contract, then it may depend on any offers you received, emails or discussions or representations made by the company at the time you were hired. So that's always, something to dig into. I haven't heard of employers putting limits on health benefits coverage. In the case where you go on leave, I'm assuming you may be taking a personal unpaid leave. And in that sense, if they're self-funding, they may, they may cut your coverage off at that point if you, again, don't have a contractual entitlement to that coverage, if there's no guarantee of health benefits being provided to you in your employment contract. So, as with a lot of this stuff, the questions, the answer really depends on if you have a contract, it's governed by the contract, and we need to see that in order to be able to give you advice. If you don't, in this case, then you really don't have an entitlement to that coverage, and they can modify that at their leisure. And Jay comes back. Thank you for the info. Thank you, Jay. We appreciate it. We're glad that you find value in this. We all love doing this. I love being able to help people, a bunch of people at once, and we all love doing this. It's a service we're happy to provide, and we hope you find some value in that as well. So we have a question coming in from Donna through email. Donna asks, can your employer put you back on a probation period if you are moved into a new position? So Donna, great question. Yes. Generally, your employer can, especially if you're being transitioned to a new position. If you're signing a new employment agreement, they can make probation a term of that agreement. You would want to maybe talk to your employer about that. Typically, where things like probation clauses are put back into contracts where you start a new position, you want to make sure that, for example, your length of service is recognized, probation or not. If you've been at a company for 10 years and they move you to a new position and they put you in a probationary period for that position because it's a step up and you don't know, neither of you knows whether you'll like it or you'll succeed in it, you want to make sure that your previous 10 years of experience with the company, for example, is not erased. Okay, technically, when you sign that contract, if there's no guarantee that they'll recognize that in the event of a termination, your severance entitlements would be severely curtailed, or could be, depending on the language in the termination clause. So if that's happening, a probation clause in and of itself isn't determinative of what your severance entitlements will look like if you have previous history. But it is a factor that is looked at by the courts when determining that. So, if you're in that situation and they want to put you in a probationary period, I would have them, in writing, state that they're going to recognize your prior years of service, enumerate those years at that time if you can, in whatever agreement you're making. If there's an employment contract and making you sign a new one, put that in there. Yeah. Okay. So I think it looks like we're out of time. I think we managed to hit all the questions today, which is something I always endeavor to do. So thank you for joining us today. As I said, the next event is the next one of these question training sessions is Wednesday, August 10th at 1 p.m. with your Samfiru himself. That's 1 p.m. Eastern time. Please join us, hit like, subscribe if you find this useful. Tell your friends if anyone has any questions. Like I said, no questions too small and only the odd question too big. Reach out. Happy to answer your questions. Have a great afternoon and evening, everyone.